All right, Miss, are you Jeffrey Oliver, sir?
Yes, sir.
All right, we have up next, people be Jeffrey Oliver. It's filed 25-6979FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Attorney Sarah McGregor on behalf of Jeffrey Oliver, Your Honor.
All right, good afternoon. We're here for a docket call and continuation of the bond matter for failing to appear. And I've been handed a plea agreement in this matter. Is that how we're to proceed today, counsel?
Yes, Your Honor.
Okay, Mr. Oliver, would you raise your right hand for me, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can put your hand down, Ms. Goodrich, you can approach. All right, Ms. McGregor, I've been handed an amended information, which I think removes, well, let's see, removes the drug doubles from count one. And it's to a habitual third on them. Do you consent to the filing of the amended information for purposes of plea taking?
Yes, Your Honor.
And do you and your client waive the reading?
Yes, Your Honor.
All right, Mr. Oliver, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So if you have a question, go ahead and ask it. I'm happy to answer it. If you need to talk to Ms. McGregor at any time, you let me know, and I can create a breakout room for you to talk privately with her. Do you understand those things?
Yes, sir.
All right, now I have to advise you the maximum penalty that you could face for the charges under this agreement. You'd be offering to plead guilty to count one, delivery of methamphetamine, and count three, tampering with evidence. Count one, the delivery of methamphetamine with the habitual third notice, is a felony that would carry a maximum of up to 40 years in prison and or a $25,000 fine. The tampering with evidence would be with a habitual third, a maximum of 8 years and or a $5,000 fine, and discretionary consecutive sentencing, meaning that your maximum exposure would be 48 years. Do you understand that, sir?
Yes, Your Honor.
Did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And you signed that form?
Yes, Your Honor.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you won't have a trial and you'll give up all those rights?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
All right, if I accept your plea, you give up any claim that it was caused by any threats or any promises outside the plea agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. But the types of issues you could raise are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides, in exchange for your plea to the charges I outlined, the prosecutor will dismiss the other charges and the habitual fourth and the drug doubles. There's the prosecutor's agreeing not to file absconding charges against you for your failing to appear at a hearing in this case, for which there's a pending contempt. And there's a sentence agreement that has two parts to it. One, that counts 1 and 3 will be concurrent, that the court will not impose the discretionary consecutive sentencing. Secondly, that there's a cap on any initial prison sentence, that the minimum sentence would not exceed 72 months, which your attorney and the prosecutor believes to be the low end of the guidelines. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Hey, counsel, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich? All right, so I do have one question about that, just for clarification. Let's say that the guidelines come out with a higher minimum range or a lower minimum range. Is it the party's intention that this would be at the low end of the guidelines, or that it would be 72 months in that circumstance?
I believe, Your Honor, that it was at the low end of the guidelines, but I'll ask Ms. McGregor if she also agrees with that.
That is what I recall in terms of our discussion.
So, I mean, you guys might be right, and it ends up scored at 72 to 180, but it's possible that maybe there's some information will come out through the pre-sentence report and we end up with a different range. So my question is, from the way the plea agreement's worded, it doesn't tell me what will happen if the range is different from 72 to 180. So I'm hearing from you both that it would be at the low end of whatever the guidelines are scored at. Is that your understanding, Mr. McGregor?
I think one of the things that we had discussed in regards to that was the court potentially not being inclined to accept something underneath that floor. So if it came back at 78, would the court not be inclined to accept a CAT of 72?
I don't know as I sit here now. I'm just asking, the way that the sentence agreement is phrased right now seems to me ambiguous. So I'm just asking for clarification about what the agreement is. I don't have enough facts to tell you whether I would agree, whether I would follow the agreement or not at this time.
My understanding in my conversation with Ms. Goodrich was that it would be the low end of the guideline range due to considerations that the court would not accept anything less than that, if that makes sense. So that is my understanding. Yes.
All right, Ms. Gooder, is that your understanding as well?
It is.
Okay, all right. So if the guidelines are different, it'll be whatever the low end of that range is. So if they come out where the low end is 60 months, then it's a 60-month cap. Is that right?
Correct.
Okay. All right. Mr. Oliver, did you follow that? Do you have any questions about that?
No, sir. Your Honor, no.
Okay. All right, Mr. Oliver, that sentence agreement, as your attorney referenced, is not binding on me. I don't have to follow it. I can make that decision once I review the pre-sentence report. But if I don't follow that agreement, you would have the right to withdraw your plea. Do you understand that?
Yes, Your Honor.
Now that's unless you engage in some misconduct. Let's say even while you're inside, you commit a crime, which happens sometimes. Then by your misconduct, you would lose the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand that?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, delivery of methamphetamine, habitual third?
Guilty, Your Honor.
How do you wish to plead to the charge in count 3, tampering with evidence, habitual third?
Guilty, Your Honor.
So, Mr. Oliver, back on December 16th of 2024, were you in Sheboygan County?
Yes, Your Honor.
It's a possession with intent to deliver. Okay, did you possess the controlled substance methamphetamine?
Yes, Your Honor.
Did you know that you were in possession of that substance?
Yes, Your Honor.
Did you have any lawful authority to possess it?
No, Your Honor.
And did you have the intent to deliver that substance to another person?
Yes, Your Honor.
Okay, and there was some police investigation into that, and it's alleged that you did something to conceal, destroy, or otherwise tamper with evidence. Can you tell me what you did that makes you think you're guilty of that?
I placed it in my coffee, Your Honor.
I'm sorry, you what?
I placed it in my coffee.
So you attempted to conceal the drugs that you were in possession of?
Yes, Your Honor.
Okay, and that was to evade their detection as evidence?
Yes, Your Honor.
And at the time, did you have prior convictions in 2019 for home invasion third degree in Ingham County?
Yes, Your Honor.
And for 2022 in Kendall County, Texas, assault of a peace officer?
Yes, Your Honor.
All right, Ms. McGregor, are you satisfied with the factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Ms. McGregor, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe I've complied with the requirements of MCR 6.302?
Yes, Your Honor.
Ms. Goodrich, do you agree?
Yes.
All right, Mr. Oliver, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense, of those offenses. So I hereby accept your plea. We'll schedule sentencing Would you be available, Ms. McGregor, on the afternoon of December 23rd for an in-person sentencing?
I will be, that is my vacation, Your Honor. I take that 2 weeks off every year.
Okay. How about, well, we could do January 6th. Would that work?
I have to be in Marquette in the afternoon that day. I have, I basically have every other day that open that week, Your Honor.
How about then January 13th at 3 p.m.?
Yes, that works.
So, Mr. McGregor, your sentencing here is going to be January 13th at 3 p.m. Ms. Goodrich, should you prepare an in-person writ for that?
Yes.
And you'll have to cooperate, Mr. Oliver, with a pre-sentence interview with the Department of Corrections probation parole agent so that they can prepare a pre-sentence report for me. We'll continue the contempt matter and continue bond to be revoked at this point. Anything further from the defense?
No, Your Honor.
Anything further from the people?
No, Your Honor, thank you.
Okay, Mr. Oliver, Mr. McGregor, I'll see you then.
Thank
Thank you,
you.
Your Honor.